Hi, welcome to another edition of IP Somm. I'm Heather Boyd, owner and proprietor of Pillar IP and a certified sommelier. Today, my guests are Stacy and Kenneth Ng, and they're the owners and proprietors of Wallpapered City in Milwaukee, Wisconsin, and my beautiful niece, Mackenzie Boyd, who's an up-and-coming artist down in Oakville, Ontario. So, Stacy and Ken, if you want to just tell us a little bit about your company and what you do, that'd be great.
Sure. So thank you for having us. We co-own Wallpapered City, which is not a wallpaper company. It's a euphemism for like painting the town red. It is a public arts agency, and we're responsible for over 40 murals in the city of Milwaukee. And we've also done some like interior murals for commercial spaces as well.
Excellent.
I'm also an IP and trademark attorney, copyright trademark attorney here in the United States.
Excellent. And Mackenzie.
As you mentioned, I'm living in Oakville currently, and I am an emerging artist, I guess you might call me. So I just graduated from the University of Toronto, Mississauga in Sheridan College, and I generally specialize in painting and drawing, usually representational, dealing a lot with my own experiences of obsessive compulsive disorder. And that's kind of where I'm headed is into the art world. So thank you for having me.
Well, thank you. First and foremost, we're going to tell us what you're drinking. I'm drinking, it's a Clausen Chase out of the Niagara region.
Wow. Pretty.
It's a rosé, so I always think rosés are perfect for spring and whatnot. So Stacy, what are you drinking?
Mine is a Sauvignon Blanc from Australia. And I remember that the year is 2017, but I can't remember the name of the label. Because I am not a sommelier.
Okay, Kenzie, I saw a mixed drink there, and I know you've got some rose gin in that, right?
I do. It's the Dillon's Rose Gin, which I am almost finished, so that's a testament to how great it is.
And that's from the Niagara region as well. So we're drinking local. Let's get right into it. The whole reason why we brought you guys together is because with COVID-19 going on, a lot of artwork is being put on the internet by up-and-coming artists, muralists, museums, galleries. And this is kind of a first where they're opening it up to the public via internet. And we wanted to talk about what your concerns are in doing that, and potentially how Ken and I will bounce ideas off each other about giving artists such as yourself some hints on how to protect that without having to spend a lot of money that artists probably don't have. So let's start with you, Stacy. Are there any concerns that you have about putting your artwork up on the internet?
Not really, mostly because, not to say that there aren't some, but what I would say is I'm also a painter and a muralist and an illustrator. I keep an active Instagram account posting my artwork. And so even pre-COVID-19, I had already sort of resigned myself to, if I'm going to have an audience, I'm going to have to share, which is inherently risky. What I do in my day job at Wallpapered City isn't so much make the murals, but because I have an agency background, I basically coordinate public art projects for other artists. I help other artists get jobs. That's 90% of the work. Every now and then I get to paint one. But that's not really my primary focus. And so what I often do is help other artists to navigate sort of these concerns about having, sometimes especially if they're a first-time muralist, it's their first time to paint something that's going to be outside of a private viewing context, like a gallery or a home. Mm-hmm. If they're used to being a canvas painter, like the beautiful one behind me, and then they start painting murals, and then people start taking photographs of their murals, sometimes it can be uncomfortable. So this is actually a topic of conversation that I love having with artists, and I love answering their questions because, you know, my co-owner and husband, is a trademark attorney, a copyright attorney. So he's been just a wonderful secret weapon for Wallpapered City, so we can help both artists and building owners, particularly with murals,
to navigate those difficult situations. Are you putting your murals on the internet or whatever for viewing gallery, and how are you accomplishing that?
Well, it's not even just me doing it. I have other people doing it because my murals have been up for years. So I get tagged because I signed it with my Instagram handle. I get tagged by all kinds of wonderful strangers who are posing, you know, couples doing their engagement pictures in front of my leopard mural, like wedding pictures, kid pictures, senior pictures, and these are all total strangers. And so it can be really exhilarating to know that you've provided a backdrop for someone's life, you know, moment. But on the other hand, it can also be like, hey, is this kosher? Is this something I should be happy with? Should I be mad? Like, you know, so it's
and we
kind
encourage
of funny.
the artists who
Right.
work with us to also post the work.
Yes.
In fact, the posting on any type of social media is encouraged and welcome, because the whole idea of public murals is essentially to create an outdoor gallery space. Without that, you don't have quite nearly as much eyeballs and attention to the space. The whole idea to public murals is to showcase the capabilities of the various artists that are featured in a particular corridor. And that, whether paid or unpaid, can ultimately lead to, as we've witnessed here in Milwaukee, Wisconsin, private contracts between private owners and the individual artists in the that have participated in a public mural project.
There's certainly benefits to artists in putting their artwork up in a public space. Obviously, recognition being one of them. Mackenzie, do you have any concerns about putting your artwork up there? Because I know you do, what is it, more realism and drawing, sketchwork?
Yeah. Normally I'm not worried as much about that kind of thing, but I think more and more we're starting to see a lot of young artists trying, well, I mean, this has always been the case, but I think we definitely are having to, just because of our financial situation, always look for alternative ways of showing our art. And so I think whether that's out in public spaces or just on the internet, I think for me, it's important to sort of know my rights and how to navigate that when I am showing my work, maybe in an alternative space like that.
Okay, so maybe Stacy and Ken can talk about what the artist's rights are when in dealing with the murals and stuff like that, because it will be virtually the same for any artist that's putting their artwork up in public spaces.
Yeah, maybe I'll talk a little bit about like common practices, and then I'll let Ken take the heavy hitting with the legal stuff. Just really quick, you know, 10 years ago, people were so afraid of putting their artwork online that they used to put these big tacky watermarks right in the middle of it. Like, here's my painting. And then they would have photoshopped some ugly logo right through the middle of it, because there was this rampant fear of having their work stolen, you know, and you just don't see that anymore. It's extremely rare to see somebody who's put a big, and I mean, they were ugly. We're talking 2004, you know what I mean? Like, it was,
they would put the big year across the whole thing.
Yeah, they'd be like big C circle and then like Susie Johnson, you know. So at least we're not doing that anymore. But I think we still have similar fears. And so we put things on Instagram, and then often in the caption, it'll be like, there'll be some comment or a hashtag, or, you know, there are things that the artist is sort of declaring, this is mine, you know, you can't. So you still see versions of that cry for protection. You know, people have gotten more creative with it. So for example, on Instagram, I follow nothing but artists on Instagram. It's entirely art. But basically you see a lot of artists do like in progress shots to promote themselves. You see a lot of like transverse angles of like the marker artistically laid on the side of, you know, with like their cup of coffee and the morning sunlight coming in. So the nugget of this conversation that we're having, as far as I can see, is what constitutes artist exploitation. Like, we're all afraid of, you know, having our art stolen.
Well, I mean, there is a segue into what exactly you have.
Yeah.
All right. So at its fundamental level, intellectual property, they're exclusionary rights, right? What does that mean? It means that when you have a right, an IP right, whether it's a patent, a trademark, or copyright, you have the right to exclude. Think of your ownership of a car or a house. If you have the deed, you have a right to exclude somebody from using that piece of property. The same with intellectual property.
It's funny how in Canada we use different language, but it means the same thing. We call it that you have a monopoly to the exclusive profit and use of, rather than just excluding other people. So,
interesting.
Yeah.
Good to know. Good to know.
Yeah.
And another point here is just to focus on copyrights. Have you heard of the poor man's copyright? The right to exclude is most difficult to prove if you cannot establish that it is yours, right? So poor man's copyright, and you can look it up online. In the old days, they would just mail it to yourself.
We still recommend doing that.
You can mail it to yourself for the cost of a stamp. And
don't open it.
Why would
don't
you
open it? Yeah.
Why would you do that? Well, because it's stamped. It's got a federal stamp on it, and it shows that that work existed as of that particular date. It doesn't have to be a drawing. It could be a poem. Could be a sketch. In the internet age, you're publishing it on Instagram on a particular date. That's already date stamped. Now, it's not a federal stamp, but it is nevertheless proof.
That's
One step further, to go to your local copyright office to secure registration for a copyright, at least for the United States, it doesn't cost very much. It's a lot less than $100. It's simple to do by yourself. I don't know how much it is in Canada, but
it's inexpensive as well, yeah, and simple to do yourself as well.
Simple to do yourself, and if you did that in the United States, you're entitled to statutory damages. This is huge because it's a huge procedural advantage, because what it entitles you to do is to not have to prove that you lost money because somebody took your copyright. You have proved that you obtain a copyright as of a particular date by virtue of the copyright registration. That registration now grants you an ability to claim a fixed amount of money, and the statutory damages varies by country, but in the United States it's fairly large, and that can make all the difference when you have a situation of infringement of your rights, your copyright. When you go to an attorney, he can then potentially look at the amount of statutory damages to be claimed and perhaps be willing to work with you for a slice of those statutory damages versus charge you upfront.
Can I ask you a question?
Yes.
So I'll give you an example of some artwork I just made that was a series, and that I was really itching to post online because I thought it was really cool and really topical. And I'm sure, Mackenzie, you can, relate to this. That's something, and you're like, "Oh, this is good. This is good. Like, I got to put this on Instagram right this minute." But then later you think to yourself, "Is that so good that someone's going to rip it off and just carry it away?" So when I hear you talk about this paperwork, and you and Heather agree, "Oh, it's less than $100. It's not that bad." I just did a series of illustrations that was called Objects from the Before Time. And it was just me doing these little still lifes, these fun.
I saw them. They were beautiful.
Thanks. So it's just these contemporary little still lifes, but it's of things we don't need during COVID-19, like household items that you miss, like your purse, a bra, party favors, bowling ball. Like, I kept thinking of all these things that are in, different people's homes that used to be something that was used and loved every single day. And now it's become like a useless object.
I know, I use and love my bowling ball every day.
Well, there you go. But I mean, like, I don't have a bowling ball, but that was a friend's example. But like, because I have a friend who's an avid bowler and now he can't bowl. High-heeled shoes, party dresses.
Dress shoes.
Yeah.
So I did this, and I was just churning them out, and I was getting crazy likes on these things. People loved them. And so I ended up making an Etsy page and like selling postcards of these objects from the before time, because now there's this craze for writing letters. So as this is evolving, I am just cranking these things out. I can crank 2 of these illustrations out a day, right? At least. And so my question to you is, because I'm sure, like Mackenzie, any visual artist can relate to this story. Would I go and file a copyright for every one of my objects from the before time? It seems like so much red tape. It seems like a waste of money, and I can crank them out really fast. I can't spend, even if it's $50, I can spend $50 every time I do a drawing. So what should I do?
The practical advice is no, you're probably not going to do that. But what you can do is you can file for one copyright application for a compilation of works. So, for example, if what you're talking about was an actual book, you submit the entire book as a copyright, which I know you have done for children's.
I have done for children's book work. Yeah.
And you cannot protect your ideas. You can protect the expression of your idea. So a copyright is the expression of your idea. An IP attorney is only going to be able to protect your specific expression. With a copyright, the way they assess it in the United States is with the test of substantial similarity. So they're going to look at points of similarity and points of difference. So take a drawing, and let's say you see something that is very similar to yours. What a court is going to do is they're going to look at a list of all the similarities and a list of all the dissimilarities. And it's a subjective test. And so something that may look close may not be a slam dunk because there might be sufficient points of dissimilarity that would make that second piece of work fall outside of the scope of exclusion from the first piece of work, if you follow.
Yeah, I think it depends on who would steal from me, what would make me mad. So if I saw that another illustrator had picked up on this idea or had independently had the same idea of still lifes of objects that they used to use before COVID-19 hit, I probably wouldn't be that mad. But like if I saw Hallmark cards come out with a whole line that was literally called Objects from the Before Time, I would be livid because that's kind of a unique title. And even if it was totally different illustrations, I would recognize what I called it. You know what I mean? Like, so sometimes it has to do with...
Yeah, but I would argue that that's probably not actionable unless they lifted one of your drawings.
Yeah.
The idea is...
And copyright doesn't cover the title anyway. Copyright only covers...
So the idea itself is not protectable just because you did...
You'd have to protect that through trademark.
Just because you protected, you have 12 drawings, 16 drawings, they're not protectable if the drawings themselves have not been copied. The next artist, Mackenzie, could come up with a whole series.
Take it. I just gave it away. Here's a free idea.
Just mark a TM on it. Put a TM on your title.
Well, let's talk about what that means. What does it mean to say TM versus R?
It means it's registered, which means the government has provided you with a monopoly to the exclusive use and profit of either that trademark or that copyright or whatever, the C in the circle. If you were just to put a TM beside something, that just designates to the public that you're using it as a trademark.
I want to go back to the question of when you should register and protect the work and spend money on the work.
That's a good idea, yeah.
I think that from a practical standpoint, think of any item that think of an apartment that you buy, or you wouldn't buy an apartment until you know what you were going to do with it, right? You're going to use it in some way. It's the same with sketches and drawings. If I'm sure a lot of artists draw every day and they don't go anywhere. But if there was a piece of work that you did and you had an intention to commercialize it, there's a commercial value to it. Perhaps you showed it to somebody. They had access to it. And we can talk a little bit about access. You need access as well as substantial similarity to find a claim for copyright infringement, right? If a particular potential client had access to your work because you showed it to them, and subsequent to that showing, you find that they've taken your drawing somehow, and they've actually used it on that wine label, used it on their wall without paying you, then you have both access as well as substantial similarity. You have a claim for copyright infringement. In those kinds of settings, should you register your copyright? Probably so. Is that 1% or 100% of your drawings? That's less than 1% of your drawings.
That makes sense because that helps me understand why you encouraged me to file for a copyright for my children's book. So I wrote a children's book called Astro Jammies about a little boy who imagines that his pajamas they're magic and they can send him into outer space. So, with Astro Jammies, we filed for copyright for all of the paintings and drawings in the book, as well as the story, because I wrote the story as well. And so that whole thing has been carefully protected because it was actually distributed. It was sold on Amazon. It was sold in bookstores. This was quite a number of years ago, about 7 years ago. And so when it was in print, it was like an active business plan for me. I was really putting all of my efforts into Astro Jammies. So that makes sense why that's like maybe I think that's the only copyright I've ever filed, because I really took an artwork and looked at it as a business plan versus, hey, I drew these cute things. I'm going to do some postcards and sell them on Etsy. Am I really throwing my whole life at that? No. If people buy them, it's cool. But
So that commercial sense is really the nub of
Yeah.
what you look at. Mackenzie, you are, and Stacy, you both create property. That property comes from your mind and from your talent and your skill, right? Not all of that talent and skill results in commercially viable art. So let's say you came up with a series of drawings you're really proud of and you posted on Instagram and you're happy to see it, and nothing came of it. You never made cards out of it. You never made any merchandising out of it. 6 months later, you find that it's for sale on merchandise on a particular website, right? It puts you in a difficult position because you haven't registered it, right? And because you don't have access to statutory damages, you perhaps can prove that you created it 6 months before, but to make an issue of it, you'd have to call an attorney and you'd have to bring a claim against this company that's selling it. Should you or shouldn't you? I would say that in a vast majority of cases, more than likely than not, the artist doesn't do anything because it costs money to do something, right?
Because it's scary.
In Canada, we tell people unless you know that someone is going to infringe or is infringing, it's probably not worth it to file for copyright registration first. It takes like a very short period of time. And you don't need to prove that you're using it or that your advertisement date, you just put in that date. So because once you go to an infringement kind of thing, you start off with a cease and desist and you tell them that you created this work of art as of certain date, and presumably you can prove that you have that date. So they either pay you the royalties or pay you fees or whatever, or they risk going to court to prove that you didn't own the copyright or it's not as similar. I mean, we use the 30% rule in Canada, so I don't know if that's the same in the US. So my question is, can you claim infringement for something even though you haven't registered for it? Can you register for it and then claim infringement afterwards?
Or you can expedite registration and you can claim infringement.
Okay.
But I would only recommend any artist do that if they feel that there is a large pile of money to be claimed from the other side, without which, I would recommend any artist, my daughter's an artist as well, to really think bigger picture. As a beginning art, as a new artist, essentially you are looking to create a style and build a brand, right? And if you spend too much time worrying about what happens in the weeds on the periphery of
then you block your creativity when you're doing that.
You're not going to go anywhere because you're going to waste money and time fighting every little skirmish and walk away from the important task of basically building a brand and a body of work that is recognizably yours.
Yeah, see, in Canada, the statutory damages are somewhere between 500 and 20,000, like $500 up to 20,000.
That's a big range. Oh my God.
Big range.
Yeah, I mean, I wouldn't go that route if that was the case. But having an analysis of what damages potentially you could have gotten or what their profit is that they've received. If you can do something like that, it would be good. But my question, Ken, is can you get the statutory damages if you don't have registration prior to the offense?
Probably not.
Okay, so you register and it's from that point forward that if they infringe that you can get the statutory, okay. But there are certainly a lot of things that artists can do in the interim to protect themselves, even if it's a Band-Aid solution. It gives them peace of mind, which helps open it up because ultimately artists want to get their work out there. You can't be recognized unless your work is out in the public view, kind of.
Well, I would say, like, for example, I can also speak as a children's book illustrator. If I'm working on children's book illustrations for a client or even for a self-published, let's say I was doing a self-published piece, and like I said, I knew this was going to be a line of revenue for me, you better believe it's not going on Instagram. It's just not. I'm not sharing this at all. I might be showing, in the way I would use Instagram or other outlets in that situation is by sharing the sketches. I would make it a whole like ad campaign. I would give little peeks into the pencil sketches. I would show a video of me meeting with the author. I would, you know, maybe do like a stop motion of something really, really quick of the color coming in. But I wouldn't take a finished illustration and put it on Instagram. I just absolutely would not, because I know that I don't want to leak that style. I don't want to leak the story. All of that's got to be protected because it's going into, I mean, publishing a children's book is like opening a new store. It'd be like opening a new coffee store. It's going to be its own small business with its own P&L. So yeah, I would be really, the way I would share would be sharing the event so that people got excited and wanted to buy it when it came out. It wouldn't be, I wouldn't make it stealable. So that's the thing I think is my best advice to artists, even if you understand the legal issues. If you're entirely a canvas painter, you don't really have commercial, I won't say that there's no commercial opportunities, because obviously there are gallery shows, but we're living in a time right now where there aren't a lot of sales, there aren't a lot of gallery shows. What they're doing is they're promoting the paintings by doing things like Facebook auctions. Yes, you see the whole painting and it is up for auction for all this weekend. You know, we're going to start at noon on Saturday and you have until noon on Sunday to make your bid.
Or virtual galleries.
Yeah. So
my grad show was on a virtual gallery.
Yeah. So like, that's a good way to do it, is thinking about, I'm promoting it because I'm selling it right now. And it's a, you know, the reason you're promoting things on social media or the internet is entirely for advertising. So you have to think like an advertiser.
I think that's the greatest advice you can give, because I know that Mackenzie's been working on some graphic design work for some clients, and making sure that you don't post that in a social media vein or which could cause a problem with the end result kind of thing.
Yeah, well,
but after it's over, you could have it on your website as a case study. Like I designed the, you know, the labels for Miller Beer.
Only if the contracts don't prohibit that. It's not unusual for an artist working through an agency to sign away their rights to the agency so the agency can sell the entirety of the works, basically a work for hire. Mm. If you want to retain it for your own promotional purposes,
make sure you build that into the contract.
You should build that into the contract.
Yeah.
Negotiate that up front, without which, you know, signing a non-disclosure agreement would prohibit you from even using it for your own promotional purposes. So it's not uncommon at all to see in a contract that the artist retains both moral rights as well as promotional rights to the work. Mm. One of the things that you need to think about as a copyright creator, a maker, if you will, is that copyright is one of the more fascinating IP rights, because out of a simple sketch, you down the line, you could have merchandising rights. You could convert it into a theater production where you have the characters on stage. You could have it on apparel. You have distribution rights, you know, both international and domestic. Storybooks.
Animation. I almost had to deal with an animation.
A whole series of characters that stem from that first drawing that get developed as derivative works that come from that first character. Now, if you sell the entirety of your works in a work for hire agreement, as we call it in the United States, then all of that has been transferred away from you to whoever is paying you for it. Mm. If you don't, and you sell them the work for the specific reason that they seek. So let's say somebody hires you, Mackenzie, to design for their website. Mm-hmm. What you give them is customized for the website and no more. Mm-hmm. It's not a work for hire. It's a license. I've given you this to do this specific task. If you want to do it for anything else, call me. We'll negotiate a price. And that's difficult to do for a new artist. As you get more senior, as you get more, the pricing differential for a work for hire, a full buyout as the industry will call it, versus versus a specific grant, a specific and limited grant, is quite big. Models do this, artists do this, and that delta allows the client to go, well, we don't have a big budget, so we're just going to pay you for this specific use right now. And if this takes off, or we think that this was a huge success, we'll come back to you for further negotiations on more rights from you.
You know, that's interesting because, so Mackenzie, as you develop, if you're doing both graphic design and are you doing illustration at all?
I've done a little bit here and there, usually just kind of odd jobs for money, but it's not my main focus. But obviously I want to.
You're a representational painter. I feel like that would be a natural fit for you.
Yeah, no, absolutely. It's always an avenue I keep open. Yeah.
Well, so an example of this is, I think there's an interesting dichotomy here. Again, it's between legal and practice. I'm trying to translate the legal stuff into like real practice. So if I were negotiating a contract for a license for somebody's website, let's say it was a kid's website and they wanted to use my little Jimmy character from Astro Jammies. That is entirely in my style. I painted him according to my vision of how a little bobble-headed little illustrated boy should look in a children's book. Entirely original. So I have unfettered rights to how Jimmy looks, the fact that his name is Jimmy, his hairstyle, his eyes, his little feet. So that's all me. Now, Mattel once hired me to do illustrations of lots and lots of different outfits for Barbie, for a Barbie app. You would never know that it was me that did that, because they were like, here's how Barbie looks. Here are the specifications. Here's your color palette. Here's the body shape, like a you know, a cutout. And they were like, we need ball gowns, bathing suits, you know, workout outfits, da da da, you know. And I came up with all these outfits to fit the paper doll. I mean, that was full buyout. Like, they're not buying my creativity. I'm just a grunt, basically, who can draw. And
that's the kind of work I've done in that. Yeah, it's not been my style by any means.
It's like, how do you like this pink ball gown? Good. There's $3. So I think that the way you negotiate your contract also has to do with the nature of the work you're doing. Are you selling your original idea and they're buying it because it's a Mackenzie Boyd, and you've established a style that people are like, shit, excuse my language, I need a Mackenzie Boyd character here. Yeah. Or is it just Mattel or Harley Davidson or a famous brand like that saying, draw Barbie, draw a Harley Davidson motorcycle, you know, follow these guidelines and here's your money. It's a big difference.
Mm-hmm. Among seasoned artists, they'll tell you, when you first start out, you take any job that you can because it pays the bills. But as you grow your brand and you build a brand for yourself, as you build a reputation and more importantly, a style that is unique to yours, because you're able to find clients that like that style, and that style is refined from one client to the next, you're able to then lessen the amount that you do for other people for just money and move in the direction of more your style. Mm-hmm. So you go from nobody to, you know, you're Madonna. This is all I do. And if you want me, this is my style. You come to me, or you come through my agent before you come to me. You might be in a position, actually at every point in this process, you can think very carefully about whether you want to assign your name to it. If you're doing just commercial work for Mattel.
Oh yeah, I would never put my name on that.
It's theirs, they can put their name on it. You
That's
don't
just
want
dirty work.
Why? Because you're brand building.
Yeah.
You know?
So I guess what you're if I can translate a little bit here is artists really need to see what value they hold in the artwork that they're preparing. And in some cases, maybe you require the assistance of an agent to help assess how much value is attributed to that work of art.
Absolutely right.
Yeah.
Does that make sense?
Sometimes.
So if we're going to do like a quick fire, what are the tips that we can give to artists, you know, when it comes to putting their stuff up online? Why don't we just go through a list of considerations that they should do, or quick fire tips that they can do to mitigate their damages, protect themselves, make sure that they are the true owners of the value in their IP that they're creating. So who wants to start?
One, decide what you're posting and why, and think like an advertising agency. You know, you should be posting things that are promoting a larger story. Two, develop your own protectable style. Invest in having a visual language that is uniquely your own, because that is property that you can sell. Not to say that you're not going to sell illustration services or design services or commission services to follow instructions, but cultivate your own style so that people will start paying you for the thing that only you do. Those are my top two.
I would add a third, which is, and we've talked about this earlier, follow the money. If there's a commercial venture, if you're engaged in a commercial venture, maybe you don't post.
So the tips I have is make sure anything, any artwork that you create and you want to post online, put a copyright notice on there. You have automatic copyright from the day it's created. So make sure you tell the public it's yours, and you're the only one who has exclusive rights to the use and profit of this. It's a Band-Aid solution, but you know, it may deter people from actually grabbing it. The other thing I would suggest is make sure that people have a contact information for you, because if they like your artwork and they can't get in touch with you, maybe they're just going to grab it. Mm-hmm. If they can contact you and you tell them how to contact you, they're more likely to say, hey, can we use this? Here's how we want to use it. And potentially that could be money in your pocket. Make sure you're policing every once in a while to make sure that, you know, your comic book character or your child's book character doesn't end up on other, like on a Mattel.
That's actually really great, Heather. I've got like a Google, I've got a Google, you know, you can do a Google search.
And it's free.
Yes, you can do Google search alerts. Yeah. Free. So for example, whenever I have something that's a word I know I could search on, my own name, for example, and also the word Astro Jammies or certain lines from the book, I've actually got on Google search alerts. And so if the word Astro Jammies ever comes up, I get a Google search alert.
Well, that's great.
And that way I know that nobody's selling like space pajamas or something and calling them Astro Jammies, because I would certainly go after them. You can.
Yeah. So absolutely 100% police your rights, because there are people out there who will think, oh, that's a great thing. And you don't have to sue every single person. Get someone like me or Ken in your back pocket, a specialist who really does look for working with artists and making sure that their rights are protected. We'll be able to look at it and say, it's probably not worth it for you to try to chase after them, because they're not making a lot of money. So why bother with the effort? Or they've got deep pockets. Let's try a cease and desist first. Let's do some negotiation. Let's figure out how we can maybe promote your image a little bit more and get you another gig or a deal with them, because they've already used it for free the first time. I mean, there are certain ways of being able to deal with these kind of things that don't necessarily cost a lot of money. And that's, you know, the starving artist, it really is a thing, right, Kenz?
Oh, yeah. No, it takes a while.
Make sure you have an agreement or a contract with a company that's in writing. And if you can't assess what you're giving away in that contract or agreement, come talk to people like Ken or us, because we can look at it and tell you what you're giving away and what you are keeping.
That's right. Sign a contract first. If they want to begin right away and say, well, we'll worry about the contract later, don't be afraid to say no. Have in your contract a way to get out.
Always, yeah.
You will, in your career, find yourself in a situation where you just don't like working with this client. They're difficult. They are slow with payment. And you're going to be grasping at straws if you don't have language in your contract to say, I have a unilateral right to basically
terminate
the relationship, yeah,
without any sort of breach of contract claim by the other side.
Yeah.
For sure.
So, and then we can talk about competitions, art competitions and stuff. So
yes, I want to have a whole discussion with a whole new drink about why you should never enter art competitions.
I'm so excited to hear about that.
Okay. All right. Well, thank you so much for being my guests here today. I learned a lot about what's going on in the US. I actually learned a lot more about how artists can actually protect themselves, and best practices for artists.
Good.
And that translates across, it doesn't matter whether you're in the US or in Canada or whatnot. Thank you so much for being my guest. I'm just going to sign off here by saying, thanks for joining us. If you liked what you saw here, please like, share, comment below, and subscribe to our YouTube channel. We'll have all the information for Stacy, Ken, and Mackenzie in our information below. And remember, we're not providing legal advice here. We're just sipping something and talking IP.